The issue to think about this is it's a growing problem. It's not just a Johnson Amendment problem. It's a growing problem of hiding things in the tax code, and then you can't challenge it. And what we don't want to train either Congress or state legislators to do is hide everything in the tax code that it has nothing to do with actually raising revenue and actually bringing in money to the federal or the state coffers.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. Now you're listening to the Napa Legal Podcast, where we explore religious liberty from the perspective of faith-based nonprofit organizations. For today's special episode, we're joined by our guest, Tyler Martinez. Tyler is Director of Litigation at the National Taxpayers Union Foundation's Taxpayer Defense Center. In addition to his work as a litigator, Tyler is a lecturer on various nonprofit, tax, constitutional, and administrative law issues. He teaches continuing legal education seminars, lectures law students, and was a quick and much appreciated fill-in at our lawyers conference in Washington, D.C. just a couple of weeks ago. So Tyler, thank you so much for joining me again, second time in a week, actually.
Oh, happy to be here. Thank you for having me twice. That means you must like me.
Yes, we're happy to have you. And this is, you had emailed me about this case that we're going to talk about today, the National Religious Broadcasters case, I think a couple of weeks ago. And we had been following it, and then we thought it was over a few months ago, and now it's not over. So I figured it'd be great to have you and talk about this case in particular. But I want to back up and talk about the Johnson Amendment and its effect on religious organizations in particular. So let's start at the beginning and talk generally. Can you just give us a little overview of what the Johnson Amendment is?
Sure. The Johnson Amendment affects what we call 501c3 nonprofit organizations. So that's Internal Revenue Code 26 USC 501c3. Initially, there wasn't any prohibition on political activity in that code, but that was put in by then Senator Lyndon Johnson, who later became president. He put that into the code without any comment. There was no legislative reporting. There was no committee reports or anything else. It was just put in and voted on, and it passed. The general consensus is that then Senator Johnson didn't like that certain churches were coming out against him politically in an election year in Texas. And so he found a way to silence them via the tax code. That has been the law since the 1960s. What constitutes political activity is a complex question. It depends also on what type of flavor of 501c3 organization is. There's different levels of scrutiny basically between what is a typical nonprofit like National Taxpayers Union Foundation or some of these other groups. But then churches have a slightly more rigorous review of what this will be. And private foundations, those that have gifts to other nonprofits, have even stricter rules. So the rules are really complex. It's a facts and circumstances test. That's 11 factors that no one knows how to apply. It's a mess.
Yeah. So my kind of gut instinct, I think this is supported by some of the circuit cases that I've read, but so 501c3 status, if it was a government benefit bestowed by choice by the government, then okay, yeah, you can have some strings attached to what you can and can't do as a recipient of a government benefit. But my understanding of C3 status more properly is that it's not so much a benefit bestowed by the government, but it's a recognition that a religious nonprofit, in this case, is not properly subject to taxation. I think that's supported by the way a determination letter from the IRS is worded, that they're recognizing rather than bestowing nonprofit status. But anyway, with that bias or angle in mind, it would alarm bells go off that why are these organizations having their First Amendment rights limited when they're recognized as C3s? Am I missing the ball here? What's going on?
Right. So the way C3 status is done in real life, as a lawyer who has an organization like a church that's trying to organize as a 501c3, you write a letter to the IRS and say, here are the things that we're going to do. We're a religious organization. We're a church. And you get to act like a 501c3 until you get to the determination letter. That determination letter sort of recognizes, as you said, like the reality of this is a religion. Now, keep in mind that this isn't just about tax benefits. There's also the establishment clause, right? Like the government doesn't get to choose who's a church and who isn't. There's a lot of cases on this. Sincerely held religious beliefs is sort of the standard, but it's not, the government doesn't get to say what is a real church or not a real church. That's sort of a foundational principle under the First Amendment. That's an important thing to remember when churches apply to this. Now, as that goes, that's just recognizing that there's already somebody has a religious belief and are organizing as a church.
Right. So then I think with that backdrop, you can say that the Johnson amendments are at least suspect, if not likely to be unconstitutional, denial of First Amendment rights to an organization. At least that's my take on it. So if we have this much suspicion of the constitutionality of these laws, they've been on the books for something like 70 years or around there. Why haven't we had a ruling on the constitutionality? Why is it so hard to challenge this question?
It's hard to challenge this question because it's in the tax code. So I agree with you. I think there's a double constitutional problem here, both under the First Amendment. It's a problem under the freedom of speech, telling people what they can and cannot say, but it's also a problem under the religion clauses. So, under the Establishment Clause. So you would think this would be a slam dunk, easy case, right? But you can't get into federal court because there's something called the Anti-Injunction Act. The Anti-Injunction Act was designed to keep people from being able to sort of keep from ever having to pay taxes because they'll just sort of litigate it forever. Like that was the idea. And so it says Congress restricts the jurisdiction of federal courts. That says that if you're going to impede the collection of federal taxes, you can't, the federal courts can't hear it. Now you can sue for a refund or you can find some other avenues, but you can't just say, hey, I don't have to pay this tax. That makes sense on its face, except it's read so broadly that this First Amendment violation, in many people's view, this really important constitutional question cannot be heard by federal courts.
Yeah. So that's it's a big problem, and let's use that to maybe segue into the particular case that we wanted to talk about. So this is National Religious Broadcasters versus Commissioner. There was a settlement. Was it late last year? Is that right?
Yeah, in 2025, yes.
Okay. So how did this case arise, and what are the basic facts and issues at play in the National Religious Broadcasters case?
Sure. So this case actually started under the Biden administration, and it was a challenge to the Johnson Amendment. There's a lot of issue with churches worrying about being able to talk about the issues of the day and politicians' stances on various issues and being able to talk about that and how that affects morality and public morality. This case started in the Biden administration, and then they amended their complaint, and it was during the Trump administration, this current one, that the case was continuing forward. Once the administrations changed, the Trump administration's officials said, I think your reading of this case is right. I don't think that the Johnson Amendment needs to apply. This ban on political speech doesn't need to apply from the pulpit, basically. That when people are talking about, when churches are discussing morality and public issues, that the Johnson Amendment doesn't apply there when it's within the congregation. It's meant more for things outside, buying TV ads or something like that. So they can come up with a consent decree, and they try to agree to it. And the key part of the consent decree really gives the whole game away. I want to read from it. It says, speech by a house of worship to its congregation in connection with religious services through its customary channels of communication on matters of faith concerning electoral politics viewed through the lens of religious faith does not violate the Johnson Amendment. So in other words, just talking from the pulpit or like a live stream of a pastor speaking or whatever on this issue would be fine, as opposed to buying out ads or something else.
Yeah, I think that's a really important clarification. And I was not seeing the nuance, or I think just the correct reading of the settlement agreement when this first came out last year. And I think I wrote a piece at somewhere, First Things Magazine, maybe, saying no, churches still can't endorse political candidates. Because you're right, I'm glad to have an expert confirm my reading of it. That the settlement agreement said we're not going to enforce the Johnson Amendment against the preacher from the pulpit talking about a candidate. But if that preacher then goes out and takes out an ad in the New York Times on behalf of the church endorsing this or that candidate, there was nothing in the settlement agreement saying that's okay, right?
Right. And in the settlement agreement, of course, is only about the IRS versus the particular plaintiffs there, but it would be a teaching tool and sort of set and establish a persuasive precedent for people to follow later on.
Right. Yeah. So it gives us an insight into what the IRS is or is not going to enforce, regardless of the outcome of the case. So then we get the settlement agreement that was several months ago, and then just a few weeks ago, we received the updated news that the settlement agreement was rejected by the court for, I think, some of the reasons that you had mentioned. That the court said that it lacked jurisdiction to enter this settlement agreement. Can you talk a little bit more about, this is foreign territory to me, these kind of tax laws and jurisdictional issues. So can you say a little bit more about this and about whether that argument is legitimate?
Sure. So, I mean, far be it from me to say that my opinion matters more than a judge, but I'm happy to walk through it. The case's opinion starts out with, this case involves eligibility for federal tax benefits. Like, that is the opening line. And once you see that line, any public interest lawyer who deals with this sort of thing knows the game's over. We've completely lost. If it doesn't start out, this is a case about the First Amendment, and instead is about framed as tax benefits, we're worried. And the issues there's a trio of statutes, basically. There's the Anti-Injunction Act, which I mentioned earlier. The Declaratory Judgment Act says federal courts can declare rights and all kinds of things and what the law is for all manner of things except tax disputes. And then there's a Tax Injunction Act, which is the same idea, but for state taxes. So you have these trio of statutes that are basically trump cards that just completely stop public interest litigation if they remotely touch on taxes. And here, what both the plaintiffs, the couple of churches and the national religious broadcasters and the IRS both said, we agree there's jurisdiction here. And the court said, well, wait a second, I have to solve this jurisdictional question first. And it just read it very broadly. And that's in part because of the very broad decisions by the Supreme Court in a few cases. It first started with Reagan versus taxation with representation, which said that 501c3 status is a benefit. It confers a benefit on that Congress has given to taxpayers to not have to pay taxes on things. And then the next case was Bob Jones University, which dealt with this same sort of issue. How much can you regulate the speech and viewpoints of a 501c3 under the tax code? And quite frankly, the Bob Jones University is pretty broad. So because the court framed this as the plaintiffs are saying, well, we should still get this benefit and get to do with what we want to speak, rather than starting out with first principles, the court sort of rejected it by just how it's framed. There are exceptions to the Anti-Injunction Act when it comes to registration and reporting and sort of information gathering requirements, but the court said that didn't apply here. That's a case called CIC Services versus IRS, which we were involved in as well. Given that this jurisdictional bar, the court said, I can't hear the case, which means I can't approve the settlement. And if you can't approve the settlement, that's fine. They could agree in mediation or some other informal way, but it wouldn't establish that strong precedent that would last from the next administration and so on and so forth in the future.
Right. Now, again, this is a layman I'm not a tax expert by any stretch. So I guess what's the difficulty I have here is if the purpose of the Anti-Injunction Act in particular is to prevent an organization or a person who is filing a lawsuit from basically not having to pay their taxes, but these are already C3s who are not paying these taxes. So what's practically the problem? Because it is a constitutional dispute, and it's not like there's a tax bill owed and National Religious Broadcasters is filing a lawsuit and not having to pay taxes in the meantime. So I assume that has something to do with the wording of the law, but why in a case like this is that an issue?
It's a hard issue because it is already a C3 status. So the typical way to get a tax case before a regular federal court, not tax court or anything else, the typical way to do it is you would pay the tax and then sue for a refund. Okay. That's the typical way to do it, right? You say, I should get more in my mortgage interest deduction or whatever, and I'll pay what the government says I owe, but I'm going to do that under protest and say, hey, I'm gonna get my refund later. that works for typical tax cases. It doesn't work for this sort of constitutional litigation. And that's been the real problem. And so what the court said to do is, well, they could just give up their tax benefit status. The churches could just, not be 501c3s. And then that means, well, they have to pay taxes as a corporation and all these other things. Now, note that there's downstream effects. The congregational members who are donating, who usually take the tax deduction on charities, can't do so here because their church is no longer a charity. Their church is no longer a church, at least for tax purposes. And that's a very dangerous purpose. The other issue that the court didn't really address, but is laying in the background is if a 501c3, whether it's a church or an educational group or whatever, if they violate this, there are taxes that are immediately due as punishment. They're penalties. And these taxes are on the organization for however much money they spent on public political activity, and on the managers who didn't supervise themselves well enough. And so the court's kind of saying also, hey, by the way, if you violated this, you would also have these immediate taxes due. They're not really taxes. The government's not relying on this as revenue. It's a penalty, but it's because it's in the tax code. There's a sort of formalism that still exists to judges that say, if it's in the tax code, it must be a tax. And this is a growing problem for any nonprofit. This is a growing problem for a lot of things as smart legislatures realize that you can hide things in the tax code and it can't be assailed by challenges later on.
Yeah, we've seen that in some high profile cases over the years and decades. So, and also if those immediate penalties are classified as taxes, then presumably if those come up, you have a hard time challenging those and getting an injunction for the same reason because it involves a tax, right?
Right. And when you look at these sort of penalties, the big case that's been recent from the Supreme Court is National Federation of Independent Businesses versus Sebelius, which was about the Affordable Care Act. Some people call it Obamacare. The Obamacare challenge dealt with, hey, they put this in the tax code and there's a tax penalty. Can I even bring this challenge? And the Chief Justice had to kind of work his way through some pretty thin readings in order to get through saying it's not a tax for the Anti-Injunction Act, so we can hear this case, but it is a tax for the purpose of upholding the Affordable Care Act as the taxing power of Congress.
Yeah. So then we end up in this strange situation where if I understand correctly, the only way forward for national religious broadcasters or a similar challenger to the Johnson Amendment is to, like you said, either forego their 501c3 status, pay a tax, and then actually have standing to sue, or to just they get out from under the First Amendment restrictions, or else keep their C3 status, and I suppose just push it to the limit of political activity to get an enforcement action by the IRS, and then have something to challenge. Neither of which is a desirable place to be in for a church. Is that about right?
That's about right. So there's a couple other paths, but they're complicated. So I would never suggest, and I don't think most lawyers would ever suggest, that you violate the tax laws, because the revenue man always gets his keep, right? And you don't want to voluntarily get into that enforcement world. The court points to three other places you can go, but they don't really work. He says you can bring it to tax court, because tax court is it's not a court under Article 3 of the Constitution. It's not part of the independent judiciary. Instead, it is a statutory court that Congress created. It's informal, and I will tell you that all the times that any kind of First Amendment challenge or constitutional issue comes before the tax court, they go, "We don't know how to do this. We know how to calculate if you owe this tax because you didn't get this exemption," right? Like, they're kind of accountant lawyers. They're not like the kind that think about constitutional issues. The other avenue is the Court of Federal Claims, which is sort of the same sort of problem, where those judges are thinking in economic terms. They don't really think in big constitutional issues. And the last one is you could bring this case theoretically under a statute directly to the District of Columbia. This case was the National Religious Broadcasters case was brought in Tyler, Texas. So it was brought in the Northern District of Texas. So they could choose a different venue, maybe, and get a declaration, but that path is not at all clear at all.
Yeah, it's procedurally very interesting. And now I'm curious to hear what happens next. So the settlement agreement was rejected. The case was dismissed. I believe I read that the National Religious Broadcasters and the other plaintiffs are intending to appeal this to the Fifth Circuit. So if that appeal goes up, would that be an appeal limited to deciding the jurisdiction question concerning these injunctions, declaratory judgment laws, and tax disputes, or would an appeal be able to get to the merits of the Johnson Amendment constitutional question?
Well, since this is in the situation of a consent decree that was proposed, I think they're going to have to just focus on that jurisdictional question.
Yeah.
My running joke in my career is that I care a lot about public interest, and so naturally, I'm an expert now in standing and jurisdiction because courts are always trying to kick cases on standing or jurisdiction. I think they're going to have to fight that out on jurisdiction on the appeal. The other aspect of this is the administration also said they're going to try and issue guidance on the Johnson Amendment and find out what's going to happen there. My concern about that is in various years, it depends on the year, there's budget writers that out of Congress that says that the IRS cannot, or the Department of Treasury, cannot write rules concerning political activity and 501c3s. Um, Congress can say what various agencies can spend money on, and they can prescribe and say, no, you cannot talk about these issues. And so I don't know if that means there's going to be notice and comment. I don't know if there's going to be like revenue rulings or what, because they can't spend money creating these rules going forward, but we really do need clarity.
Yeah, so that's an interesting issue. So I suppose, I mean, like there are a lot of situations in which law enforcement agencies, state and federal, will just choose non-enforcement on certain things that don't align with their priorities, their policies. So, is there? This wouldn't be a permanent solution because this only would last as long as the administration. But could the Trump administration, the Trump IRS, say we're just not enforcing the Johnson Amendment? Like people can do as much political activity, and we're just not going to touch it, or is that going to run into legal problems as well? I know it's not a permanent fix.
It wouldn't be a permanent fix. They could say that. I mean, and we've seen that in very controversial questions before, like immigration, right? The Biden
Right.
administration said we're not going to enforce a whole bunch of aspects of the immigration law. And then as soon as President Trump came into office, he switched that out because it's prosecutorial discretion. They get to pick and choose their cases.
Yeah.
It's not a permanent fix. They could do it, but what we need is clarity going forward because, churches are established for in theory forever, right? Like you're talking about people's eternal souls. They want to always be there. They don't want to just last for one administration or another. One thing I do want to add though is it's not like the sky will fall if churches start talking from the pulpit about politics or about candidates. Whether or not one thinks it's a wise choice, before the Johnson Amendment, churches all the time, you had your union church and you had your corporation church, and people went to sort of self-selected. That's a little different for like Catholics who have to go to territorial parishes or whatever, but nonetheless, people picked and choose, especially on the Protestant side of things. It wasn't the end of the world. People were fine with it. It's just an invention from the 1960s that we're dealing with now.
Right. Now the need for long-term clarity here and this looming constitutional issue, I think, are quite important. And for the long-term fix, it seems you can get a constitutional challenge through the courts if you can navigate this process and actually get a ruling on the Johnson Amendment from a First Amendment perspective, or you could have a statutory repeal of the Johnson Amendment, right? Both would be long-term fixes. Both appear to be quite difficult to achieve. So I'm curious, do you think, I know the statutory repeal, it got brought up in 2017. It happened again last year when this case was going on. I forget what senator brought a repeal, but they don't tend to go anywhere. So what do you think is the likely path forward for the long-term, challenge to the Johnson Amendment?
Well, I think the status quo will stay for a while where, churches have to be silent and worry about how they do this. There has been proposals. It was in the 2017 tax reform bill, the big tax reform bill, but it got washed out due to procedural problems in the Senate. The way the case, the way the statute was brought forward to the Senate means that only certain things can be thought of in amendments, and so that one was removed. I think there's appetite among various members of Congress to do it, but they need to build a coalition still, and it's Congress hasn't been congressing very much lately.
Yeah, that's right. Well, this is really helpful. Obviously, we'll be watching this. I'm curious to see what happens if it goes up to the Fifth Circuit, if this is just going to get kicked and we'll be, back to square one. But I guess closing thoughts. Do you have any either final thoughts on this Johnson Amendment situation, or also anything else relevant to our listeners on religious organizations that you'd like to end with?
Sure. I think the issue to think about this is it's a growing problem. It's not just a Johnson Amendment problem. It's a growing problem of hiding things in the tax code, and then you can't challenge it. And what we don't want to train either Congress or state legislators to do is hide everything in the tax code that it has nothing to do with actually raising revenue and actually bringing in money to the federal or the state coffers. It's a big deal, and you might find fellow travelers if you run into this in other areas of law, right? Like we've already talked about the Affordable Care Act, but there's other areas too. And so I would say for your listeners who are trying to deal with this and head scratcher, talk to other colleagues too, because you'd be surprised who else would know stuff about it. And of course, we know it here at National Taxpayers Union Foundation.
Yeah, this is a fascinating point. And are there anything that comes to mind, any specific instances besides the Johnson Amendments, places where things that would affect religious organizations or religious liberty in general are hidden in the tax code? I'm very curious about this issue.
Well, right now that's the big one. There's some minor like spending. You can't spend it on money to religious organizations or those sorts of things. In the States, of course, you have Blaine Amendment sort of things where that attack religious schools, mostly aimed at Catholic schools. It was an anti-Catholic movement. And so you still have these things, and the states have the same rules. They have the same, like, you can't bring this case in state court unless you go through the Bureau of Tax Appeals, and you bring it to the Bureau of Tax Appeals and they go, what is this? I don't know what this is. And so things get sort of lost, and it's a real growing problem because basically most judges go, ooh, taxes are icky and I don't know what to do with this.
Yeah. Yeah, no, that's fascinating. That's a great point to end on, because it really reinforces what we do at Napa Legal, which is preach that the boring stuff in the law matters, right? It's fun to get fired up about like a church autonomy, constitutional litigation issue, but corporate governance, taxation, state compliance, these things are hot religious liberty issues. They actually affect the ability of religious organizations to do what they're supposed to do. So thanks for shedding some light on the tax issue here.
Well, thank you for having me.
Yeah, and we'll be following this closely. So maybe we'll talk again and see where this case goes.
Sounds good.
Good. All right. Well, Tyler, thank you so much for joining us today. And thank you to our listeners for joining us for this special episode of the Napa Legal Podcast. As always, if you enjoy the content we're putting out, we appreciate it if you like the podcast episode, subscribe to our channel on YouTube or Spotify or wherever you happen to be listening from. And if you want to check out the work that we're doing, you can do that at napalegalinstitute.org. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.